Good afternoon, everyone. Thank you for attending today. Welcome to our Wednesday webinar. Burkitt Long is offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. By way of introduction, I'm Tej Thacker and I'm the Head of Regulatory Law here at Burkitt Long. This week, we are looking at how to protect your business during health and safety investigations. We'll be taking questions at the end of my presentation, so please do make use of the Q&A facility. Next slide, please. So the purpose of today is to provide a broad overview of the health and safety regime and in particular various facets pertaining to inspections, investigations and enforcement steps that can be taken by the relevant regulators, whether it be the HSC, the local authority or such like, and what steps can be taken by a suspected party to preserve their position and protect their business interests insofar as it's possible in the prevailing circumstances. Next slide, please. So just a bit of housekeeping. The information in this presentation is for general purposes and doesn't constitute specific legal advice. The details are correct as of today's date, the 23rd of March, but of course subject to legislative changes. So health and safety is an obvious and natural concern and indeed a priority for all businesses, certainly in most recent times, across a whole range of industries and sectors. With increasing regulation and an ever-growing burden on businesses, the consequences of a failure to comply with health and safety requirements can be severely damaging, not just financially, but also for morale, reputation and brand. Next slide, please. Accordingly, in the first instance, it's necessary to look at the legislative framework. Indeed, there are several bits of legislation which assign health and safety responsibilities, both general and specific in nature, upon employers, employees and also third parties. These can be identified within the Health and Safety at Work, etc. Act 1974, the general duties, regulations, which deals with the specific obligations, approved codes of practice, or otherwise known as ACOP, published guidance and development of principles and interpretation established by case law. Next slide, please. So dealing with the Health and Safety at Work, etc. Act 1974. That was created in response to a number of serious workplace incidents which occurred over the years and exposed the real need for central legislation. The Act is the primary piece of legislation covering occupational health and safety in Great Britain and contains the general and overriding health and safety duties, which firstly employers have towards employees and members of the public, secondly employees have to themselves and to each other, and finally certain self-employed people have towards themselves and others. But it also acts as the framework for other statutory instruments and in particular the regulations I mentioned before pertaining to health and safety that originate from European law. For example, there's regulations concerned with the management of health and safety, personal protective equipment, control of asbestos, provision and use of equipment or hazardous substances, just to name a few, but there are certainly several. The regulations are all substantive insofar as they create positive and detailed health and safety duties upon businesses, generally in the management of health and safety and also where action is required in response to a particular hazard, or industries where hazards are particularly high, such as construction or agriculture, for example. They're the two with the highest fatality rates. These will naturally need to be carefully considered and factored into the approach when seeking to comply with health and safety requirements incumbent upon businesses in their respective undertaking. So turning to those general duties, having regard to the overriding objective about preventing injury and maintaining health. Next slide, please. Sorry, could you go to the slide before, Katie? So it's an employer's duty, so far as reasonably practicable, to protect the health and safety and welfare of all of its employees. You've got that quote up on the screen. That includes a number of facets. So firstly, appointing a competent person. A competent person is someone with the necessary skills, knowledge and experience to manage health and safety in your business. It's a duty to assess all the risks, including those that could foreseeably arise. For example, in an office environment, fire, first aid, workstation assessments, manual handling, electrical hazards, driving at work, lone working, and in more recent times, stress and mental health, and certainly COVID. There's a requirement to consider, evaluate, record and implement. And it's important to note that if you can't eliminate, then certainly you should be controlling those hazards. You've got to provide adequate information, facilities and equipment, and you've got to develop a procedure and a written policy. And the key takeaway there is if you've got 5 or more staff, then it does need to be a written policy rather than just having factored it into your overall steps. Having emergency procedures and consulting employees is naturally key, as well as displaying the health and safety poster, having insurance liability provisions in place and naturally staying up to date. Compliance requires any policy to be reviewed and revised periodically, or otherwise when a situation arises giving that need to take those steps. You go on to the next slide, please. So following the risk assessment process, employers have a duty to adequately control any identified risks following a hierarchical approach. And it starts with the most effective, which is naturally to eliminate risk. But if that's not possible, you then go through that hierarchy you can see on screen by controlling your risk at source or by implementing a safer design, using physical engineering controls and safeguards, which are supported by safe systems of work. And finally, what is identified as the least effective approach, but no doubt an important approach, which is through the use of personal protective equipment. And perhaps it's noteworthy to mention that that's without charge to employees under Section 9 of the Health and Safety Act. And from April 2022, I believe from the 6th of April, the law is amended to the provisions of such PPE that all persons required and not solely employees are needed to be given with that personal protective equipment. Next slide, please. So the general duties on employers and self-employed are under Section 3 to conduct their undertakings in such a way as to ensure, again, so far as reasonably practicable, that persons other than themselves or their employees are not exposed to risks of health or safety. To be engaged, there's three important elements. It must be a duty holder, it must be a risk of someone not an employee or self-employed, and the risk must arise from the undertaking conducted by the duty holder. It may seem fairly obvious, but in terms of the issue of whether that duty is engaged, is dependent on the facts in each particular case or set of circumstances. The leading authority is identified in the case of RV Associated Octel Co Limited, 1996. And whilst it's not decisive in every case, whether the duty holder can exercise control over both the conditions of work and where the activity takes place is very important in identifying that position. It's perhaps worthy to mention that under Section 77 of the Act, it's worthy to note there's also statutory duties upon others in furtherance of eliminating or reducing the risk to health, safety and welfare. In particular, Section 7 deals with employees, and they have a duty to take reasonable care for the health and safety of themselves and others who may be affected by their acts or omissions whilst they're at work. So this extends to cooperating to enable the employer to fulfil its legal duty. Health and safety legislation generally recognises that for success to be achieved in the manner it is intended, it requires others to conform, thus those concerned with the premises, employers, self-employed, and likewise under Section 7, those employees. Go to the next slide, please. So as I mentioned, both general duties under Section 2 and Section 3, those duties on businesses are qualified by the term reasonably practicable, affording some degree of protection. It's a narrower term than what is or may well be physically possible. And in summary, it involves weighing up the potential risk against the trouble, time, money needed to avert or control it. Therefore, it requires a degree of common sense and an exercise of judgment on a case-by-case basis. But let's be clear, the case law very much says it weighs in favour of health and safety, and the more significant the risk, the more likely it is steps have to be taken and reasonably taken. The process isn't one of balancing the costs and benefits of measures, but rather of adopting measures except where they are ruled out because they're grossly disproportionate sacrifices that are involved. And it's important that if you are facing proceedings under Section 40 of the Act, there's a reverse burden. The burden is on you to demonstrate on the balance of probabilities that it was reasonably practicable insofar as what you've undertaken, and if you haven't undertaken certain steps, why it wasn't reasonably practicable for you to undertake those. However, it is equally worthy to note that, particularly concerning regulations, that where risks are significant, they are not qualified by the term reasonably practicable or otherwise best practical means, and there is a duty and an obligation to undertake what is required. Go to the next slide, please. So when considering whether the duties and whether the steps taken by the business can be deemed to be reasonably practical, it's imperative to have regard to the ACOP, the approved codes of practice and published guidance, and in particular knowing the difference between the two in the context of their respective legal status. You've got on your screens a summary that deals with what amounts to guidance and what amounts to approved codes of practice. But the key takeaway is the legal status that is assigned to each. In particular for guidance, there is no particular legal status per se. Following the guidance isn't compulsory unless specifically stated, and you're free to take other action. If you do follow the guidance, you'll normally be doing enough to comply with the law. Inspectors do seek to secure compliance with the law and may refer to the guidance in any way, shape or form. But it's a different position when you consider the approved codes of practice. Approved codes of practice are approved by the Health and Safety Executive with the consent of the Secretary of State. It describes the preferred or recommended methods that can be used or the standards to be met to comply with the regulations. It does have special legal status. As I say, you have to follow it or show compliance. If you follow the advice, you'll be doing enough to comply with the law in respect of those specific matters on which the code gives advice. You do have the option to use alternative methods to those set out in the code in order to comply. However, the code had that special legal status that I mentioned is important, because if you're prosecuted for a breach of health and safety law and it's proved that you did not follow the relevant provisions within the code, you'll need to show how you complied in some other way, otherwise you are immediately deemed to be at fault. And go to the next slide, please. So turning to the regulator, the HSE, or the Health and Safety Executive, is the predominant regulator for occupational health and safety. Their functions are itemised in Section 11 of the Act. Their wide and far-reaching role. They have significant statutory powers, discretionary functions, and they undertake research and the provision of training and information. They also make representations as to the making of further regulations, provide particulars about how it's going to fulfil its function, and importantly have a role in regulatory investigation and enforcement, which are criminal offences. So the HSE will generally be responsible for investigating and enforcing health and safety. However, local authorities, in particular environmental, fire service and police, to name a few, can and will be actively involved. There are various memorandums of understanding, which are effectively documents between the authorities and the regulators. Its purpose is to ensure the effective collaboration and working relationship between those organisations where their duties for health and safety enforcement and accident investigation overlap with one another. But that being said, in the majority of cases, the HSE will take the lead. Now, the HSE is accountable to the public for the decisions it takes and their implications. And to that end, it has published standards and policies that it equally must adhere to. Next slide, please. So the HSE are well known to, and indeed openly publicised, that they proactively carry out targeted ad hoc inspections and interventions in high-risk sectors, workplace and occupations, with the view of ensuring health and safety risks are being managed effectively and reducing the new cases of incidences that are arising. And doing so, they use a broad range of enforcement methods. The HSE is fairly open. It states that their purpose for enforcement is threefold. The first is to compel those with a duty to ensure that the health and safety of others to take immediate action to deal with the risk of injury. Secondly, to promote sustained compliance with the law. And thirdly, to ensure that when there is a breach of health and safety legislation, that the offender is held accountable for that failure and is responsible. As I say, the HSE has produced a policy on enforcement that sets out 4 underlying principles it adopts in accordance with the Enforcement Concordat, which must of course always be borne in mind when things go wrong and one is confronted with the prospect of enforcement action. The first is proportionality. Now, this relates to enforcement action to the risks and takes into account how far the duty holder has fallen short of what the law requires of them. The measure taken to control risks will be judged according to what is reasonably practicable, and the authorities will search for that evidence of good practice was followed. And again, I make reference to, back to the position regarding published guidance and ACOP if you're shown to be complying with that. As I've mentioned, targeting, this means ensuring that those employees whose activities give rise to the most serious risk are adequately controlled. The third is consistency, which means following a similar approach in similar circumstances to achieve similar ends. That effectively means that everyone is treated on the same level playing field in the same set of circumstances. And finally, transparency. That means that the HSE and the enforcement of health and safety legislation means that they should help duty holders to understand what is expected of them and what they should expect from the enforcement authority upon inspection. It's not a case of attending, detecting and penalising. Their endeavour is to work with duty holders and businesses to secure compliance. Now, these should all be at the forefront of your minds and referred to, certainly when making any representations to the regulators for and on behalf of those facing enforcement action. So if we get to the next slide, please. So what happens if things go wrong? You'll see on your screen a list of the key features in the cycle of a health and safety enforcement process, and the steps which progressively increase in terms of severity and the sanctions that one can expect. If we go to the next slide, please. So dealing first with inspections. So visits or site inspections from the Health and Safety Executive can arise for a number of reasons. First is following a reportable incident under the Reporting of Injuries, Diseases and Dangerous Occurrences Regulations 2013, otherwise known as RIDDOR. Now, RIDDOR affects anyone who is an employer, self-employed or in control of a work premises, and depending on the particular circumstances, it gives rise to a prescribed set of obligations. Under the RIDDOR regulations, employers or self-employed and people in control of work premises have a legal duty to report certain serious workplace accidents, occupational diseases and specified dangerous occurrences, i.e. those near-miss instances. The purpose of RIDDOR regulations is to allow the Health and Safety Executive and local authorities to monitor accident trends, identify how risks arise and investigate serious accidents when they do occur. So to comply with RIDDOR, the duty holder needs to report and importantly retain records for certain types of incidents that are prescribed within the regulations. To deal with some of them, specified injuries. Now, there are different tests on whether or not the impact is to a worker or non-worker, but in essence, they deal with bone fractures, crush injuries, burns covering more than 10%, significant damage to eyes or respiratory systems or other organs, or if there's been loss of consciousness. There's a 7-day incapacitation rule. That means if someone's being away from work or actually unable to resume full range of their normal duties for more than 7 consecutive days. And there's a change, a landmark change recently, insofar as it used to be 3 days, but the regulations amended that to 7 days. If it's non-worker, if they've been taken to hospital as a result of a work-related accident, and I make note of that work-related accident provision because you often see it in schools. If someone, a pupil has an asthma attack, whether it's work-related accident or not, may come down to whether or not it was as a result of a physical activity, a PE session, or ultimately since it was just an asthmatic attack. But one needs to look at whether it was a work-related accident, and if you're unsure, it's often best to err on the side of caution. The requirement is to report it in the quickest practicable means or otherwise within a prescribed period of time by the regulations. Now, that's either 7 or 15 days or as soon as possible when it becomes apparent, depending on the specific circumstances. It's worthy to note that it's offence in its own right not to report when you are required to do, and that's distinct and in addition to any underlying breach. And it will also be considered in the context of any subsequent investigation, otherwise deemed either a mitigating or aggravating feature. And actually could influence the decision in terms of the potential route of enforcement. As I said, you always want to consider the PR element as well. Certainly, if there's work-related death, for example, in a school, and there's an argument, a grey area as to whether or not it was a work activity, you may often find from a PR perspective it's better to report and be seen to be complying and cooperating with that process. Now, the second incident or second occasion upon which a site inspection can take place can be as a consequence of a complaint. This might be from an employee, including a safety representative, or from even members of the public. The complaint might be anonymous, and in most cases, inspectors of the Health and Safety Executive will not initially disclose the fact that they are visiting the premises to investigate such a complaint. Or may thirdly otherwise be as part of a routine inspection. They will usually have a program, the HSE will usually have a program of inspections that determines the regularity of visits. This in turn will depend on the level of risk presented by the activity undertaken at the premises, but the frequency can equally depend on previous compliance records, accident records, and generally the business's attitude towards the regulator and towards health and safety as the concept. During a routine inspection, inspectors will look at a range of matters. They can look at a whole host of things, but generally it will include housekeeping, the state of the premises, equipment, how it works and whether it's been maintained, your systems of work that are in place, and the policies and procedures and the training and such like that you implement throughout the course of your business. Next slide, please. So this deals with investigations following on from an inspection. So if having attended the HSE believe they've identified suspected breaches of the health and safety legislation, or whether it be the Act or the regulations, they carry out a formal investigation. That can range from an inquiry by a single inspector to a large inquiry involving numerous people from a range of agencies. Unless there is sufficient restriction to the contrary, regulatory inspectors have far and wide-reaching powers that are conferred within Section 20 of the Act. Now, this includes the power of entry. Inspectors may enter premises at any reasonable time. This means that an inspector may enter the premises at any time while the premises is open, including during any night shift work. Although it would somewhat be unreasonable, however, for the inspector to require entry during the night if the premises are not usually open overnight. The inspector doesn't need to make an appointment, and often they don't. It's an ad hoc surprise visit. Now, unlike the police, the inspector does not need to obtain a court order for entry to the premises. However, the inspector should carry a warrant that shows their identity as well as their authority, and it is good practice for the employer or the business concerned to ask the inspector to produce his warrant and have sight of that if there is any doubt as to the reason of their attending or their identity. It's worthy to note that any attempt by the employer or business to prevent inspectors from entering the premises can result in a prosecution against them individually or the business itself for obstruction. Inspectors may also take police constables with them if they anticipate any serious obstruction, and the inspectors may also take another inspector with them or any authorised person, for example, a specialist or a medical doctor. On entry, inspectors can perform one or more number of tasks as conferred within their statutory powers. And there's a whole host of them, and it can range from taking photographs, measurements, records, details, taking samples of articles. They can require pieces of equipment to be dismantled. They can take items into their own possession, so components of equipment or the whole equipment itself. And they can have that examined and tested. They have the power to require the scene, particularly the scene of an accident, be left undisturbed, and the power may be invoked by telephone before they even arrive at site. They can request records, plant inspection reports, results of surveys, risk assessments, policies, procedures and such like. And they can also request the use of your own facilities to assist them in their duties. So they can ask for your office to conduct various interviews with individuals. In addition, it's worthy to note Section 22M of the Act is an overarching and all-encapsulating power which allows them to do anything that's necessary for the purpose of carrying out their duty under the statute, which is to preserve health and safety and welfare of individuals. Inspectors also have the power to require people, and I believe it's Section 22J, they've got the power to require persons who they feel may help their inquiries to answer questions. Now, it's an offence to refuse to answer such questions depending on the circumstances, such as to whether or not formal powers have been invoked or exercised, and the status of the person being spoken to. For example, are they being spoken to because they have information that will assist, or are they being spoken to in the capacity of a suspect? And that includes whether it's a nominated representative of the business or whether they are being suspected in their individual capacity. Any individual being suspected has the right to remain silent and not self-incriminate. So it's important to clarify that at the outset. Now, this will usually be employees of the duty holder that's being interviewed, rather than individual directors or managers potentially at the outset themselves. Inspectors do use the same rules of evidence collection as the police. It's under the Police and Criminal Evidence Act. So this means that any such interviews with witnesses may be tape recorded. Where an inspector does require anyone to answer questions, they often require them to sign a declaration as to the truth of those answers, and none of those answers can be used in evidence against the person who gave them, or indeed their spouse, just for the purpose of completeness. So they can be used against others. For example, if employees are giving witness interviews and details, they cannot be used against the employee directly, but they can be used against the company in any subsequent proceedings. It's important that as tempting as it may seem, it's an offence by company, employer or individual to prevent or attempt to prevent any other person from appearing before an inspector or from answering any questions which the inspector is entitled to ask by virtue of their formal powers that they invoke. It's also an offence to intentionally, it's an offence to obstruct or intentionally provide the inspector with false statements or falsify entries in a register, book or other documents which the inspector may wish to see. If we go to the next slide, please. So legal professional privilege, I'm just going to touch on this briefly because it's a whole subject in itself. The issue most likely arises and is predominantly concerned in the area or the arena regarding internal investigation reports. If an accident report is not privileged, and so after an accident where the company undertakes an investigation and produces its findings with a view of ensuring that it doesn't happen in the future, and that's a general obligation under the health and safety legislation, but is also conferred as a specific obligation under some regulations. So, for example, the coma regulations, a serious major accident, there is an obligation to investigate and remedy. But if that accident report is not privileged, the health and safety can demand it and use it as evidence against the company. So a document that you produce yourself, it can use against you. However, where an accident investigation is carried out by or on instruction of a lawyer, and it's carried out for the sole or dominant purpose of reasonably contemplated litigation, civil or criminal in nature, then the HSE cannot compel you to provide that. The findings and documents of that investigation will therefore be privileged and are excluded from those Section 20 powers. Now, as you'll appreciate, it's a very grey area. The HSE will suggest that documentation isn't covered by privilege, and no doubt businesses will suggest it is covered. And when does that privilege, that cloak of privilege, become engaged? The leading authority is the case of the SFO v ENRC Limited in 2018, and in particular the Court of Appeal's most recent decision, or latest decision, in overturning the High Court ruling. The decision had been welcomed and will give comfort to corporations wishing to conduct an internal investigation. In the aftermath of the High Court decision, there had been a concern that if a corporate conducted an internal investigation to get to the bottom of the alleged wrongdoing, it could potentially make matters worse for themselves by creating materials that could be disclosable in future proceedings. Such a position placed corporates, and particularly large corporates, who wanted to remediate the issue, in a difficult position. The Court of Appeal, having essentially returned the position now to the status quo that existed prior to the High Court ruling, and what it effectively has done, it's created the watershed moment, which will come much earlier than the point in which a criminal investigation is formally commenced, and companies and their legal advisors can breathe more easily knowing that they will not be responsible for identifying that a criminal offence has in fact occurred before they can rely on that cloak of privilege. So the Court of Appeal made it clear that the decision turned to the facts in that particular case, but whether or not litigation privilege is applicable in an internal investigation will be fact specific. But corporates should instruct external counsel and legal advisors early and receive advice about preserving that cloak of privilege. If litigation privilege is considered to apply, this should be documented so there's an audit trail and can be relied upon at a later date. And there should continue to be designated client groups and investigation reports who liaise with that external counsel, external legal advisors, and drafted accordingly. Next slide, please. So, in addition to the investigation process, the HSE can invite the company by virtue of its representative, or indeed an individual, if they are suspected in their personal capacity, to a formal interview under the provisions of the Police and Criminal Evidence Act 1984. And that process provides for an important evidence gathering exercise, perhaps where the HSE would otherwise be unable to obtain relevant evidence. It's an important process in terms of revealing information for further lines of inquiry, and it's also relevant in terms of any prosecution or enforcement decision that is subsequently taken. Now, it's a vital aspect of any investigation and subsequent enforcement decision that is reached. As I say, in the first instance, it's really important to ascertain the identity of the suspect concerned. Whether you are, as a company, as a separate legal entity, are being invited to attend the interview, i.e. the person in attendance is there as a nominated representative, or whether they are there in their personal capacity, having regard to Section 37 of the Health and Safety at Work Act. In short, Section 37 says that where an offence is committed by a body corporate, but is proved to have been committed with the consent, connivance, or otherwise attributable to any neglect on the part of a director, manager, secretary, or similar officer, or indeed anyone holding themselves out to be in that position, they too shall be guilty of the offence and shall be liable to be proceeded against and punished in addition to the corporate itself. So where an individual is to be accused in their personal capacity, it's advised the company nominate a different representative. However, if the position is not known until much later, for example, during the course of the interview process itself, then there should be two separate interviews conducted, one on behalf of the company where the individual is there as a nominated representative, effectively being the voice of the company, and a second one in his individual capacity where he can personally elect whether to answer or invoke his right to silence. And you've got to have in mind that the rules of admissibility, should the matter proceed and come before the courts, about what can and cannot be used against the individual and vice versa. Now, there are important steps and options in the course of a formal interview process, noting that the purpose of the interview, on the one hand, is an evidence gathering exercise, and on the other is to ensure that such person has an opportunity to offer account, importantly, if he or she chooses to. The HSE don't themselves have statutory powers of arrest like the police do. They can't come and handcuff you and compel you to an interview. Thus, usually the request is made in writing for the suspected party to voluntarily partake in the interview process. Therefore, it is initially wise to seek full pre-interview disclosure from the regulator with the view of gaining a summary of the precise allegations being articulated, together with the advanced production of any documentation that will or even may be put to the suspect directly or via its nominated representative. Therefore, it's important to ensure that any relevant inquiries can be made and fully informed, detailed, complete and accurate responses can be given during the interview process. There's often a degree of reluctance on the part of the regulator to what's commonly construed as showing their hand, but as I say, they are there to gather the evidence, and if you are there as a nominated representative requested to provide responses, it may well be that you may need to make advance inquiries so that those fully informed responses can be articulated. Having received any such disclosure, there are various options available when partaking in the interview process. So option number one is you attend and answer all the questions posed. Number two is you attend and make no comment. Option three is the provision of a prepared statement under caution together with any relevant enclosures. And option number four is dealing with it by way of questions and answers in writing through your legal representative. When deciding on the approach to be taken, it usually depends on the specific circumstances. However, more often than not, a prepared statement or written replies to questions is usually the best course of action to adopt, in my view, certainly, with the view of preserving one's position in the prevailing circumstances and managing the defence's position, having regard to the principles surrounding adverse inferences that could be drawn from any silence or non-responses to particular questions. So, moving on to enforcement action, if we go to the next slide, please. Under the health and safety legislation, there, as I say, the regulator has a range of powers and enforcement methods at their disposal, all of which can have a cataclysmic impact to the duty holder, the business, and the ongoing viability of the business in its operation. Now, they can do a whole host of things, from providing you with information and informal advice or even formal advice in writing, issuing notices of contravention, serving enforcement notices, varying licenses, conditions or exemptions, issuing cautions, and perhaps the most grave action is finally by way of prosecution. Now, when making these decisions, the HSE states that it does take into account the economic growth and impact their actions are likely to have on a business. However, if criminal proceedings are initiated, regard must be had to the Sentencing Council guidelines, which I'll come on to shortly, which are effective from the 1st of February 2016 and must be adhered to by courts, which effectively removes the cap on fines and imposes fines based on turnover. But I will get to that towards the latter end of this presentation. Dealing first with enforcement notices, if we could move to the next slide, please. So, as I say, the purpose of enforcement action is to make sure that legal duties and obligations are being complied with. And one of the key tools available to the health and safety or the local authorities, if they are pursuing enforcement, is the use of enforcement notices. There are two types. First is an improvement notice. An improvement notice may, and I've underlined may, noting the discretion, be issued by an inspector from the health and safety or the local authority if, in his or her opinion, a person or a business is failing to fulfil a legal duty in relation to health and safety or is likely to fail. So there's no actual breach required. And that improvement is required to ensure future compliance. In general, the notice should set out what evidence this opinion is based on and what duty the business or individual has breached or will be believed to have breached, They may also set out what action is required by what prescribed date. Failure to comply with an improvement notice is a criminal offence in its own right and can result again in unlimited fines or a prison sentence if it's an individual that's concerned. The second type is a prohibition notice. Now, a prohibition notice is a very serious sanction. It'll be issued where an inspector from the regulator is of the opinion that an activity is being carried out or likely to be carried out that involves risk of a serious personal injury if continued. It ultimately brings the activity in question to an end unless the specified conditions have been met, and it usually has an immediate impact that can be, I say immediate impact, there are few circumstances it can be deferred. But again, a failure to comply with prohibition notice, or in fact any enforcement notice, is a criminal offence. Now, having an enforcement notice issued against you might impact your approval under contractual approval schemes or your chances of success if you're tendering for work, especially from public authorities and governing bodies. If you or your business is issued with an enforcement notice, it will be recorded against you and will be taken into account in any future investigation or enforcement action or criminal proceedings. And it's recorded on a public register that's accessible online through the HSC website. It'll have insurance implications, no doubt. And the fact that an enforcement notice has been issued is also likely to raise your risk profile with the regulator, which means you're more likely to be under greater scrutiny and regulatory oversight, whether that is by virtue of increased visits or otherwise. Next slide, please. Now, a person or a business on whom an enforcement notice is served can appeal against that notice. An appeal against an enforcement notice by the regulator is oddly enough heard before the employment tribunal or lodged before the employment tribunal. A notification of an appeal against the enforcement notice must be made to that employment tribunal within 21 days on which the notice is served. Now, in the event of improvement notices, the requirement is automatically suspended when you lodge the appeal pending the outcome. However, for prohibition notices, the lodging of an appeal doesn't automatically suspend the requirement. However, a distinct and separate application can be made to the employment tribunal for the requirements of the notice to be suspended pending their outcome. If the company does not accept the contents of the notice served on it, it really should properly consider appealing. Now, the grounds of appeal can include generally that the enforcement notice is not justified, there was no breach, there is no risk, that it ought to have been served on another party, and that can often be seen where there are two parties involved and one is blaming the other. That's particularly relevant, for example, in the construction sphere under the CDM regulations, or if the terms are vague and otherwise generally unreasonable. So on an appeal, the employment tribunal can do a number of things. They can modify the provisions of any prohibition. They can dismiss the appeal, or they can quash the enforcement notice in its entirety. Now, there's been recent case law developments regarding the appeals of enforcement notices, and the Supreme Court decision in the case of HA Inspectors of Health and Safety versus Chevron North Sea Limited. That's the first time the Supreme Court have become involved in hearing an appeal concerning whether the service of a health and safety enforcement notice was justified or not. And the issue that the Supreme Court was asked to decide goes on what is the nature of an appeal against a prohibition and improvement notice. An employment tribunal hearing an appeal against an improvement or prohibition notice effectively is now entitled to take into account material that was not necessarily available to the inspector at the time the notice was issued. It overturns the previous ruling that was in place from 2015. And effectively, the Supreme Court ruled that on appeal against a prohibition order, the employment tribunal was entitled to take into account all available evidence to the state of affairs at the time of the service of the notice, including information that came to light afterwards. So if, for example, the health and safety inspector believes there's a risk and you subsequently have experts come in and assess that risk and they find there was no risk present or potentially present, then they can actually take that into consideration on appeal. So, you know, the Supreme Court effectively have adopted that approach, having regard to the position potentially being agreed between parties, having the face or the risk of prosecution if they fail to take the remedial measures, and the exposure to reputational damage that includes obviously having those details publicised on a register on the HSE website. So whilst the decision will undoubtedly be welcomed by organisations and obviously solicitors and legal advisors for those duty holders, there is perhaps a hidden danger, and that is, could the HSE in criminal proceedings later rely on that failure to appeal an enforcement notice to prove that at the material time there was a risk of a serious or personal injury? The answer may be to enter an appeal whenever there is a risk of prosecution, on the basis that in the vast majority of cases an appeal is going to be stayed until the conclusion of the criminal proceedings. More positively, clients are encouraged to consider whether there is whether or not there's already existing material in existence that contradicts the opinion of the inspector, and that coupled with any further material that can be obtained. If we go to the next slide, please. So this deals with fees for intervention and notices of contravention. I'll take this fairly shortly, but a notice of contravention will accompany any enforcement notice. And in addition, the HSE can issue what's known as a fee for intervention. And a fee for intervention, or an FFI, is a fee payable for the time spent by the HSE in identifying the material breach, assisting in putting it right, investigating and taking enforcement action, which includes site visits, written notifications, taking statements, getting specialist support, and so on and so forth. Now, if such material breach is identified resulting in the notice of contravention, then the FFI will naturally follow, and it has to be a material breach, so not just a breach, but a material breach. And that if they issue an FFI, it'll usually mean that they send out invoices to the company every 2 months that require payment in 30 days. And that means they can usually recover the cost of their investigation as they're doing it. And it's usually, I believe, a sum of £157 an hour. Now, where the business disagrees with the invoice, for example, because it disputes that there's a material breach, or it disputes the amount of time being charged. For example, if an inspector suggests it's taken 7 hours on an inspection and you believe they were there for 1 hour, then the procedure is as follows. The invoice must be queried first within 21 days of the invoice date. The HSE will then reply to the query. Where it's not agreed by the business, it can raise a dispute. Now, the business must submit the written reasons for the disagreement within 21 days of the HSE's initial response. And there is obviously a risk, because if your dispute is not upheld by the panel, then you've got to meet the cost of the panel's hearing. But again, if you are disputing an FFI on the basis there is no material breach, and there is a criminal prosecution pending, often the FFI appeal will be stayed pending the outcome of the criminal proceedings. So there are benefits and risks to appealing it and not appealing it, but it's something to naturally bear in mind whether there's been a breach and indeed whether there's been a material breach. If we go on to the next slide, please. So turning to offences, charging decisions and prosecution. Section 33 of the Health and Safety of Work Act creates offences for breaches of the general duties contained in the Act, or indeed numerous supporting regulations. If safety breaches within the workplace cause or significantly contribute to death, then those responsible are more likely to face prosecution for corporate manslaughter, or common law manslaughter by gross negligence. Where there's been a breach, in deciding whether or not to prosecute, the regulator has to follow the Code for Crown Prosecutors and apply the test on the balance of probabilities. The first part of that test is there sufficient evidence to provide a realistic prospect of a conviction? Now, that's a different test to what the courts need to convict. Is there a 51% chance or not that we can secure a conviction based on the evidence we have obtained? The second part of the test, which equally must be met, both parts have to be met, is it in the public interest to prosecute this duty holder? Now, usually that's going to be satisfied unless there is some specific public interest reason not to, given that it's health and safety. Furthermore, the more serious the offence, and including any injury, the less persuasive the public interest factors will be. But importantly, businesses can influence the decision of regulators. So it can make representations, in addition to any representations on appeals of enforcement notices, FFIs, any details given at police interview, PACE interview. They can make written representations to the regulator, and when making those written representations, they need to consider the factors set out in the enforcement policy statement. But it's also important that you look at the wider picture and the wider context, because you can influence the decision Again, unlikely if there's serious injury, but generally you can influence the decision by referring to cooperation, the provision of information, previous compliance records, prompt remedial action or steps undertaken, and alternatives available against prosecution. Now, if the regulator decides nevertheless it's going to prosecute, the majority of offences available are either way offences, i.e. they can be heard in the Magistrates' Court or the Crown Court. The strongest factor in whether the magistrates consider themselves to have sufficient sentencing powers is going to be any potential level of fine, having regard to those guidelines which we're going to come on to. But even then, it can decide to keep a case in the Magistrates' Court and remit sentence. But the things that they'll generally consider is, are there technical or complex issues, which there often can be in health and safety cases, or whether there's been a death. And if there are both of those facets present, it's more likely than not that it's going to proceed upwards to the Crown Court. As I mentioned earlier, that the criminal standard and burden is so that the burden of proof is on the regulator to prove beyond a reasonable doubt. That is so that a court can be sure of liability. Whereas if you are relying on a defence of balanced probability, defence of reasonably practical steps and means, it's on you on the balance of probabilities to prove your position, and thereafter for the prosecution to disprove your defence on that criminal standard. I put their insurance provisions, and I mentioned that because it's always important to check legal expenses cover if you are facing prosecution. Check employers' liability insurance, public insurance liability, and directors and officers' liability. It may cover the defence costs, but it does not usually cover the cost of fines or prosecution costs. Moving on finally to sentencing. So the maximum penalty, if we go to the next slide, please. The maximum penalty was previously £20,000 for a company and £5,000 for an individual per each offence. In March 2015, the upper limit and cap on fines were removed generally, and therefore the maximum fine increased to an unlimited sum, and individuals convicted of breaches could be sentenced up to 2 years imprisonment or anything in between, community orders, suspended sentences and such like. The Sentencing Council introduced new guidelines for health and safety offences, given the disparity in sentences that were being imposed, and that came into force on the 1st of February 2016. Now, the Sentencing Council broke down the sentencing process, so to speak, into 9 steps, which are to be followed to determine the appropriate and just sentence for an offence in respect of breaches of health and safety legislation. So in the first instance, they need to determine the offence category, and to do that, the court looks at factors to identify levels of culpability and level of harm. That would identify a starting point and category range. Once the offence category has been decided, the court will refer to tables for different sized organisations, and on your screen I've put that there are different categories, and I've put the medium category, which deals with those companies that have a turnover, and it's important to note turnover, not profit, between 10 million and 50 million. The court will assess the organisation's annual turnover equivalent to reach that starting point or fine based on what level of culpability and harm category is identified. Thereafter, the court should further consider adjustment within that range, depending on whether there are aggravating or mitigation features present. And as part of that process, the court will check whether the proposed fine based on the turnover is proportionate to the overall means of the defendant. They'll consider those other factors that I've said, mitigating and aggravating features, and indicate whether there is to be a reduction. For example, assistance to the prosecution, or a reduction for a prompt guilty plea. Now, if you plead guilty at the first reasonable opportunity in any criminal matter, you are entitled up to a maximum of a third reduction of any sentence. So, for hypothetical purposes, a fine of £600,000, which would be imposed if you pleaded guilty at the first opportunity, the starting point becomes £400,000. It will then consider any compensation and ancillary orders that it needs to make. For example, if there's been significant injury or such like. But it's also got to consider the principle of totality. And so, if you're being prosecuted for a number of offences, it would be wrong to identify the starting point for each offence and add them together. The court would look at the overall sentence and establish whether it's just and proportionate to the overall level of offending. albeit the additional offences may well increase the sum as an aggravating feature. And importantly, when the court imposes a sentence, it must give its reasons for the sentence imposed. I've talked about those factors that may influence it, and some of them I've mentioned: reduction of plea, principle of totality, profitability when viewed against actual turnover, ability to make restitution to victims, impact on improving conditions, employment for staff, customers, and the local economy, and like I say, assistance for prosecution. They're just some of the features that are concerned. Now, it's important that the burden is on the defendant to produce financial information to the court about the level of turnover, and usually you look at a 3-year period. Now, that's something to have in mind, because often when you're facing a health and safety prosecution or such like, auditors are seeking to make provision in the accounts, which on a prosecution, or shall I specifically say any sentencing exercise, are required to be produced, and that's going to effectively give an indication to the court on how you approach health and safety, or what level of offending you believe, or you've been advised you believe, have committed. Now, as I said, there's a 9-step process, and the extent of those hypothetical risks or relevant mitigating features are invariably going to become a contested point at a trial or a sentencing exercise, and likely to lead to prolonged hearings involving the introduction of potentially expert evidence. And it's important, though, because as you can see on your screen, the range of fines, and if we just take high culpability, harm category 1, the starting point is a fine of 950,000, but it can go upwards to 2.5 million or down to 600,000. And so those arguments are often, those legal arguments and those factual arguments are integral to identifying where you're placed on that scale. What can be said, though, is the introduction of new and very clear sentencing guidelines for the courts has increased the size of fines for health and safety breaches and linked them to the size of the company. And you know, if we can go turn to the next slide, please, I can summarise it or conclude it in this way. The HSE have produced a report with their latest statistics for 2019-2020. And it shows that they've taken 325 cases they've successfully prosecuted, but that's led to a total of 35.8 million pounds worth of fines. And the average fine for a health and safety breach is £110,000. But in addition, in excess of 7,000 enforcement notices have been issued. And it just gives you an indication that the health and safety will prosecute, the ramifications are serious, and it's really important to take the matter seriously, to put steps in place, and if you are found to be falling foul of those obligations, to preserve your position and manage the process in the best way possible. So that sort of rounds up everything up, and if we move to the next slide, before we do take any questions, we'll be sending a recording round to everyone that signed up to today's webinar, and hopefully that'll be with you tomorrow morning. And we'll also include a link to a very short feedback survey. We'd naturally and really appreciate if you could complete that, so we can make sure our future webinars are helpful to you. Next slide, please. As I said at the start, this is one of a series of Wednesday webinars. Our next webinar is the trans community and the law, a guide for individuals, and that's going to be on the 20th of April. If you are interested in our future webinars, please do visit our website or our Eventbrite page and sign up. So we'll now take any questions that you may have.
Thank you, Tej. We've had a couple. Do keep them coming in if there are any more. The first one is from James, and it is: please advise on how long an enforcement notice is visible or on record.
So an enforcement notice will be held on a database within the HSE almost invariably, because they will consider it as part of a pattern of compliance. In terms of the public database, from the top of my head, I believe it's 5 years for enforcement notices and 10 years for convictions.
Great, thank you. And the next one is: when a court is sentencing a company for a health and safety offence, can they take into account any parent or group when determining the level of fine to be imposed?
Yeah, it's a good question, actually. The Court of Appeal recently affirmed the position and sort of clarified the principles of company law. A parent company's turnover will largely be irrelevant when considering the appropriate level of fine for a company found to be in breach of health and safety legislation. And the two leading cases are MPS Limited and actually Bupa care homes. That says that it won't take it into account unless there are exceptional circumstances for what's known as piercing that corporate veil. Now the court was in that case declined to give actual reasons as to when it would take it into account, what those special factors or exceptional circumstances. But in that present case, they did explain why they didn't take it into account, which sort of gleans us as to what steps they consider. And they are effectively whether the subsidiary's organisation has delegated its duties to its parent organisation, the economic realities and the relationship between the subsidiary and the parent, whether the subsidiary remits its profits to the parent organisation is ultimately irrelevant, and the fact that finding a subsidiary would decrease the amount remitted by it to its parent organisation doesn't necessarily impact that economic reality. So if it is a company is a separate legal entity in law, and if it's not naturally and obviously reliant on its parent to operate, it won't take the parent's resources into consideration.
Thanks, Tej. That's actually all the questions we've had.
Fantastic. Thank you ever so much.